Hey guys, Richard Allen has confessed. It has been reported. Let's talk about that. This case involved the abduction from a railroad bridge of two girls who were taken down a hill, across a river, and then murdered amongst probable other crimes. They managed to capture video and audio of the person who abducted them, but the video is not clear enough to establish an identity of a particular person. Despite the video, the case remained unsolved for years, and then essentially out of the blue, Richard Allen is arrested. He's got no significant criminal record. Increasing the mystery of the whole thing, the state said they believed the person responsible for the murders did not act alone. Yet we don't have evidence of that except for communication with the victim on social media by extremely unsavory characters. Allen was charged with what is called felony murder rather than the murders themselves. That means he's charged with committing a felony that ultimately is tied to the murders. It can have the same punishment as murder, so it's not really a lesser charge. And it does not mean the state is not saying he committed the murders. It just means they're prosecuting him for the abduction that led to the murders as felony murder. And that could be an evidence issue. It also could be someone else's involvement. We don't really know. Allen, it turns out, had self-reported his presence on the bridge the day of the murder and near the time of the murders. The issues with this timeline and how it looks very bad for Allen, especially when one considers his account and the account of other witnesses, that's set forth in an earlier video. Eventually, it was disclosed that an unfired round of ammunition was found at the scene very close to the girls, and that state tool mark experts had connected this round due to extraction marks on it to a handgun owned by Allen. The quality of that match, we don't know. It might be extremely distinctive, and it might not be. Coming closer to the present, we know Allen's defense attorneys reasonably asked for him to be moved out of the maximum security situation he's in currently due to the impediment it creates for working with him on his case and its overall effect on him in a pretrial situation. They said his mental health generally and mental health is deteriorating rapidly. He certainly looks different than when he went in, right? But I agree with defense. It looks bad, and just the situation I don't think is appropriate for somebody who's on trial rather than being convicted. Now, in a hearing just days ago about his confinement situation, it came out that he has made incriminating statements, confessions. Those aren't the same thing. We'll talk about that, to multiple people in multiple occasions. What is interesting here is that apparently at the time of the hearing, the defense did not deny this, but rather put it down to Allen's mental condition and that he's under distress and making conflicting statements. I mean, a lot of times if you have, say, a jailhouse snitch saying the guy told me he did it or whatever, the defense will deny that the person ever said that because it's an unreliable source. Anyway, a confession can be powerful evidence. Related to the ongoing poll, it can be powerful direct evidence. Not every confession is true, of course, and that matters a lot because of the weight of that evidence. So as most people know, there are various rules designed to protect against abuse of rights. Miranda warnings when the defendant is subject to custodial interrogation, as an example. Certain evidence rules in many jurisdictions about recording custodial interrogations. A requirement that the confession be voluntary and not coerced out of the defendant by some means. Now, these statements could be big trouble for the defense, and they know it. I made the mistake of looking at comments on Reddit regarding this, looking for information on the hearing, and saw the Galaxy Brain comment that it doesn't matter because these statements would be hearsay and inadmissible. No, it's not even what the defense said at the hearing. But surely everyone has seen cases where the cellmate testifies and says, hey, he told me one night he did it. Stop before you say, well, they lie and they can't be trusted, etc. I get it, but do you get that they testify? The point is, can this be admissible? And the answer is yes. Yes, it can. It can be attacked by the defense on the weight of it, and they say they'll do that, but it can be admissible. Let's look at the Indiana rule on hearsay, 801D2, which is fairly typical. A statement is not hearsay if it is offered against an opposing party and was by the party. Now, you can think differently if you choose to, but that's the actual rule. So if the state asks the cellmate, what did he say to you regarding whether he committed the crime? And the defense attorney objects on the basis of hearsay, everyone in the courtroom, the judge, the jury, court reporter, jailhouse snitch, gallery, bailiffs, and even the defendant will look sadly at the social media School of Law graduate defense counsel with the unspoken admonition, do better, bro. and then the judge wearily will say, denied, the witness may answer. So Allen's attorneys who know the law, well, they may try to attack admissibility. I would if I were them at some later date, perhaps by saying he was out of his mind and it wasn't voluntary or something like that. If they don't succeed, they at least want to be able to attack the weight of the statement. And that's the approach, at least at current, they indicated in court at the hearing, saying, reportedly, confessions, non-confessions, incriminating statements, non-incriminating statements, we'll deal with that. The jury will hear all of that. That's what his own attorney said. Now, how bad could these statements be? We don't know. We don't know if these statements were made to the companion inmate who was for quite a while stationed outside his door, to an employee, in a letter. The warden says he's gotten several letters from Allen, a letter to staff or someone else. But in the context, I think it does sound like oral statements. So maybe it was on a phone or video call to a family member or friend or something like that. We don't know. A jailhouse companion saying, yeah, he told me he did it and thought he would never be caught, would be probably perceived as less reliable and weighty than if there is a video of him on a call saying the same thing to a family member. It just depends, right? Who knows? But when even the defense is admitting these statements were made, and they are, it highly suggests the state has some evidence of the statements much more solid than a jailmate claiming he said it. Because why wouldn't you deny that at this point? We don't know when in the alleged deterioration of his mental state these statements occurred. Were they all recent or across a lengthy period of time? Probably another important question. And we don't know what these statements are. Was it a direct confession with details? I did it, here's how, and here's how I left the scene. Just an I did it, or maybe I did it. Something less than a confession, say an incriminating statement. They match my gun to the bullet found there. Well, that could be seen as incriminating or just repeating what the state's already told him. Or, thank God they didn't find the knife, which definitely is incriminating, but it's not a confession. Anyway, you can expect the defense to try to lock down the he is and was mentally out of it angle if they can. But so far as I know, they were still on the issue of just trying to get him to the county jail rather than saying he's becoming competent to stand trial. Now, on that issue, if they do try that, he would be evaluated, and if found incompetent, the general route is he would be treated until he regains competency, and then the case would proceed. Because allegedly the incompetency, if it did exist, would be because of the jailhouse conditions. This is similar to how Lori Vallow was found nuts for a while before her trial, and then later treated and then later found okay to move forward with her trial. It's not some free ticket out of jail. And remember, competency to stand trial is not related and it's not the same as trying to mount a defense of insanity at the time of the crime. Those are two wholly different issues. And I'm certainly not aware of them bringing up the insanity thing with regard to the crime or even competency at this point. But sometimes people conflate those and they're not the same thing. I still do want to come back on this case with a more in-depth discussion about ways to think about the cases in general, and how to apply a system to consider probability. Jury verdicts are, in a sense, based on asking the jury to consider probability. It's just that the level of probability is not quantified in numbers by the law, but rather language. More likely than not in a civil case, or clear and convincing. Beyond a reasonable doubt in a criminal case. Scientific evidence is often stated in terms of probability, like DNA, which often gets expressed by random match probability. The likelihood that a member of the general population selected at random would share this DNA profile is 1 in a million or 1 in a billion or whatever. When it gets to say 1 in a billion, most people will think, well, yeah, that's a match for the defendant or, whoever they're trying to use the evidence against. And I certainly think it's fine to consider things without calculating probabilities explicitly, overall situations that you're in. We do it all the time in life, and that's how it is in court. But I also think trying to quantify probabilities, say as an observer of a criminal case assessing potential guilt, can possibly give you a higher quality opinion and also help you clarify your own thinking and how much the weight you're giving to a particular piece of evidence toward the odds of guilt may or may not be reasonable. It's a way to check yourself and increase the quality of your thinking. If you still have your thinking cap on, consider this. It's considered improper for a prosecutor to use the random match DNA probability as an expression of the odds of guilt. If the DNA expert says, for example, the odds of someone having this DNA profile in the general population is 1 in a million, And let's say the DNA was found in such a way that it's highly material to the identity of the person who committed the crime. The DA should not say, district attorney, should not say in closing, the math says there's a 99.999% chance the defendant did it and only a 0.001% chance he didn't. Don't buck those odds. But why would that be improper? Well, think about that one, and while you're doing it, consider this. Let's say the defense uses the same logic. Ladies and gentlemen, based on the state's own odds, because there are 10 million people in North Carolina, not even counting people who travel through, 1 in a million means there are 10 possible people who committed this crime. That means the odds of my client being the person who did it is only 10%, and it's 90% likely he didn't do it. So there's no beyond reasonable doubt here. It's beyond a reasonable doubt he didn't do it. Do you buy that? So yes, people can use statistical odds improperly in lots of ways and arguments, and it can be hard to suss out the logic errors in a dynamic situation such as a trial. So tying this all back to the point of this video, I've seen a lot of comments that Alan's confessions are meaningless, even excluding the person who said they can't come into court. I mean, people just say things they don't know what you're talking about, but it's just meaningless. The people saying this, they can't know this. They don't know what he said, how he said it, or who he said it to. But their opinion is not exactly worthless in that it exposes the person expressing it as someone who either cannot think logically or can but chooses to lie. This helps put it right in the bin with weirdos who say without evidence, the bullet found from Alan's gun was planted, or the video was altered to mask the true identity of the killers. There are many effective ways to rebut evidence. Take, for instance, the bullet. If you say the matching process, the tool mark analysis, is too subjective, and the weight of that is at best poor, and in your opinion, you don't think it should be allowed as evidence, even though it often is, that's fair, and it makes sense. It certainly will be subject to attack from the defense. It already is in a motion in limine, and if it comes in, it's still going to be attacked in court. Yeah, right. And I agree. We have to wait and see the quality. But your point that do not assume a match here, it's a very good point. But when you rebut actual evidence with harebrained fantasy scenarios based on nothing but imagination and nonsense, like confessions are meaningless, they can't come in, Eagle dropped the bullet and stuff like that, to me, that's a concession on the argument. And any further bleeding from somebody like that, it just falls on deaf ears and often goes to the ether. In conclusion, incriminating statements or jailhouse confessions may very well be admitted as evidence. Depending on how they're made, they may very well be compelling. Irrespective to that issue, though, I agree with the defense he should be moved, that his level of confinement is not appropriate for somebody preparing to stand trial and who has a right to prepare a defense and has not been convicted. I think the judge had previously agreed it's probably finally going to do something about it in short order. I will be interested after that issue is settled, how the defense tries to protect Alan from his own statements, perhaps by some competency angle. Haven't really seen that yet. Or a motion in limine, that could come later. Or just arguing the weight of it to the jury, which was what they said in the hearing, but they may change tactics later. Again, if he's the guy who did it, I hope the evidence is there to establish it, as this case needs to be and deserves to be solved. If he's not the right guy, then this is a situation of injustice, even at present, due to how he's being treated, if nothing else. Now, my position is it's highly likely that he's the guy, but that opinion certainly is not conclusive at this point in the case. Probably have a better feeling for it if we knew what these incriminating statements and confessions were, but we don't, and that's okay. That's appropriate at this point. And that's it. Thanks, bye.